Start. Learned amicus curiae has pointed out that the states have not provided information in the format given, due to which data processing is a problem. In this behalf, he was invited our attention to the fact that only states of Jharkhand and Maharashtra have given compliance, but the state of Jharkhand is the one which can be identified as having given information in the required format. Information sharing protocol is now available and has been placed on record with the note of hearing today. Before we give our imprimatur to the above, considering that the matter relates to state subject, it would be appropriate for the states to analyze the draft protocol submitted, and if there are concerns, bring it to the notice of the learned amicus curiae within 2 months from today. E-prison software of NIC is working in thousands of jails in the country, and it would now have a field where date of grant of bail would have to be entered. If the accused is not released within 7 days of the date of bail, the e-prison software would automatically generate a flag or reminder, and simultaneously the email would be sent to the DALSA concerned so that it can find out the reason for non release. This enables prison user to access the data of inmates so as to assist in identifying who are bailed out but not released due to some reasons. So far as the discussion with Tata Institute of Social Sciences is concerned, some suggestions are stated to be made, but amicus curiae submits that a more detailed work out of that is necessary. Another issue which has crept up during discussion is whether the government would give access to this portal on a protected basis to the secretaries of the state legal services authorities and district legal services authorities, which would facilitate better follow up. We call upon the government of India to discuss this issue with NALSA so that necessary directions, if any, can be passed. Learned ASG would obtain instructions in that behalf by the next date with a view to ameliorate the problems. A number of directions are sought. The court which grants bail to an under trial prisoner or convict would be required to send a soft copy of the bail order by email to the prisoner through the jail superintendent on the same day or the next day. Jail superintendent would be required to enter the date of grant of bail in the e-prison software or any other software which is being used by the prison department. If the accused is not released within a period of 7 days from the date of grant of bail, it would be the duty of the superintendent of jail to inform the secretary DALSA, who may depute paralegal volunteer or jail visiting advocate to interact with the prisoner and assist the prisoner in all ways possible for his release. NIC would make attempts to create necessary fields in the e-prison software so that the date of grant of bail and date of release are entered by the prison department, and if the prisoner is not released within 7 days, then an automatic email can be sent to the secretary DLSA with a view to find out the economic condition of the accused. Secretary DLSA may take help of the probation officers or the paralegal volunteers to prepare a finding on the socio-economic conditions of the inmate, which may be placed before the court concerned with a request to relax the condition of bail or surety, where the under trial or convict requests that he can furnish bail bound or sureties once released. Then in an appropriate case the court may consider granting temporary bail for a specified period to the accused so that he can furnish bail bond or sureties. Stop.